Hi everyone. My name is Zameer Nathani, and I'm going to speak on data privacy and cloud with respect to cybersecurity and the technology we have, the data privacy and the cloud we speak about today. And how do you guide your organization into an uncertain future? New ideas about cybersecurity, data privacy, and technology. Some recommendations from my side. Uh, just to give you a short introduction about me, I have done my master's degree in law in civil, international, criminal, UN, and WTO. I've done my PLD from Harvard Business School. I've also done my US IP laws from Stanford. I have IPR and ADR certifications from WIPO, United Nations. I've also done my private equity from London Business School and mergers and acquisitions from Harvard Business School. I was a law firm attorney where I served a lot of big clients like Eureka Forbes, LG Electronics, TCL, Motul, Ginger Oils, Johnson and Johnson, and other MNCs from US, UK, Asia Pacific, etc. I was also associate vice president of Reliance Entertainment when the real in 2006 when we started the business of gaming, OTT, e-commerce, etc. I was also head legal for Balaji Telefilms, which is India's #1 TV show. Thereafter, I was director legal for Raymond, which is world's largest producer of worsted suiting fabrics. I am presently the senior vice president and general counsel for UFO Movies, which was India's pioneering and disruptive technology provider and developer for digital formats of all movies and contents which you see in your theaters today. I'm also the recipient of Harvard Business School Alumni Challenge Award from Harvard Business School. I'm also a recipient of the Alumni Achievement Award from Narsimonji Institute of Management Studies. And in addition to other renowned awards which I've received in the past, I'm also the recipient of the General Counsel of the Year Award from Indian National Bar Association at the gracious hands of Justice Shri Krishna, ex-judge of Supreme Court of India, and who is also chairman of the Committee on Data Protection Law. Moving on, uh, this is my index. This is what I'm going to speak about on guiding your organization in an uncertain future with respect to cybersecurity, data privacy, and technology. The first thing which I'm going to discuss with you is about the data privacy aspects. The data privacy aspects is about the ownership of the data and what you need to keep in mind. Second, I'm going to speak about cloud's service level agreements which we have with the companies. Third, I'm going to speak about regulatory and compliance challenges in a cloud setup when it's relating to the banking and financial industry, confidential data theft attacks and legal ramification of the same. Then a short glance of about GDPR, which is General Data Protection Regulation, with reference to the data which is coming from the European Union countries. We then speak about integrity of customer data and third-party data, and cyber piracy, hacking, and infringement issues. And I then sum it up with an example of two cases in India on cybersecurity and two cases, international cases, which have happened on cybersecurity outside India. Going to the first aspect, most importantly, is about data privacy and ownership of the data, which is always a factor to be kept in mind, whether the data which you're sharing with Facebook and the Cambridge Analytica issue which came up where Facebook was sharing some data. Data privacy aspects, most importantly, we have to keep in mind that data privacy is a part of the data protection area that deals with the proper handling of data. So if you see on the right hand side of this PowerPoint presentation, you will see that there is a data privacy and there is a data security. Now, data privacy means that it has to be compliance with the data protection laws and regulations, focus on how to collect, process, share, archive, and delete the data. But when we talk about data security, it's about the measures which you have taken in an organization in order to prevent any third party from having access to it in an unauthorized manner. This includes how data should be collected, how data should be stored, how data should be shared with any third parties, as well as compliance with applicable privacy laws. Though data privacy and data security look similar, the distinctions are clearly once you start to dissect them. So if you see on the right hand side of my screen, I have divided data privacy and data security into two parts to explain what individually privacy and security means for each other. One of the prominent examples we have is the Facebook hacking, which happened some years ago, where there was some loophole which was there in the technology, and that is why people could have access to the data of individual users. We remember the case of Marriott credit card hacking, which happened. It was happening from a long time. There was a gap in the system which could not be made out, and the credit card data came out. Unfortunately, it also happened in Marriott New York, which at that time when it happened, I was staying in the same hotel in US during my visit, and at that point of time also. Uh, Going from data privacy aspects, it's very important for us that a company introduces and elaborate data security methods and measures to protect data, but fails to collect that data on a valid, lawful basis is in violation of applicable privacy laws in jurisdiction it operates. We hear about GDPR, European Union nations are governed, the data in European Union nations are governed by GDPR laws, and we hear about GDPR, Google, fines, etc. This is the important aspect which gets missed out during that particular process. For companies to keep the data and keep the trust, it will have to demonstrate transparency, including the purpose and who is a data processor and so on. Very importantly, very much in the news, as everybody is aware about, that WhatsApp came out with a new policy on the business, and it became a controversy that that the data will be collected by WhatsApp and can be shared with Facebook. And that's the exact point we are saying when we say that for the companies to keep the data and keep the trust, it will have to demonstrate transparency in that. A potential data breach can cost your company more than you think about. So litigations could follow, counter claims could follow, fraud cases will follow, non-compliances issues will be taken up before the regulatory authority as well as before the courts. There could be class suits which can be filed against if it is outside India. So there are real consequences. Like in the case of Marriott also, when we spoke about that there were credit card data which was stolen, and this was going on for many years, and there was a small gap in the system. Still, Marriott was fined in millions for this particular data breach. Hence, it is important to implement three strategies. Number one, data protection and privacy program. Number one should be there. Number two, automate processes. There should be escalations in the processes. There should be automation. It does not mean that one person has forgotten that things to be alerted or has got an alert but did not interpret that alert. There should be an automated process which should trigger things and navigate you through applicable data protection laws for the jurisdictions like US, EU, etc. We need to figure out that there should be a data protection and privacy program. There should be an automated process which should be in place, and this process should navigate us through the applicable protection laws which are available for US or other jurisdiction, so that we are completely in compliance when we are dealing with the data. We will now shift our focus from data privacy and protection to the cloud service level agreement. As everybody is now conscious about it, that all the data mostly is lying on the cloud, and therefore there are some cloud level agreements which have been entered between the company and the company which is providing the data and the company which is providing you cloud services. For example, Amazon Web Services, AWS, provides you cloud services, and therefore Amazon enters into an agreement with you because your data will be stored on Amazon Web Services if you're a company which is dealing with Amazon, or you are dealing with a company like Microsoft, etc. In terms of cloud service level agreements definitely have become more important as organizations move their systems, application, and data to the cloud. A cloud service agreement provides for specific services that are measurable, benchmark, jurisdictional compliance in terms of the privacy and data protection, and there are reward or penalization based on commercial usage or non-usage, including termination of services which are not permitted. All right. Now, when we speak about cloud service agreement, if I today enter into an agreement from India with Amazon Web Services in United States, and I'm dealing with a data which is based in Ireland or any other European Union nation, which means GDPR will apply to me, which means that the contract between an Indian company and Amazon in United States will have a clause in the agreement that if the data pertains to a person who's staying in European Union and you are dealing with that data in India, that data has to be in compliance with the GDPR law, because any European Union data requires compliance with the GDPR law. All right. So this is what we are talking about as part of the agreement which is provided by the cloud service company. A cloud service agreement also covers the governance, security specifications, compliances and performance, uptime statistics, and should address security and encryption, practices for data privacy, disaster recovery expectations, data location, as well as data access and portability. All right. Because today we are going to speak about the guidelines which you're going to provide to the companies. We have spoken about data privacy. We are now talking about the cloud service level agreements and what component of these clauses should be included in cloud services agreement so that you are protected and compliant with the law as a data provider or as a data receiver also, as well as the company which is providing you a cloud services. And when you're dealing with a data which is a foreign data where the privacy law is applicable to that data, and you don't want sitting in India to be non-compliant with the GDPR or any privacy law which is applicable to that data. All right. So these are the guidelines in terms of the service level agreements. We now go to the aspect of regulatory and compliance challenges in a cloud setup where it pertains to an industry which is most important is your banking and financial industry. If there is a data leak in banking and financial sector, you can imagine what kind of consequences it would occur. And one of the international cases which I've cited is about JP Morgan, and you will see what kind of losses and what kind of numbers which can be thrown up, and it completely affects a systemic point of view to that particular jurisdiction itself. All right. So what should be kept in mind when it is about the regulatory and compliance challenges in a cloud setup with respect to banking and financial sector? Number one, difficulty meeting compliance requirement. Now, when we say what does that mean? By virtue of their business, banks and insurance companies tend to be widespread geographically in terms of their presence. Now, if you think about Bank of America is a bank which has originated in the United States, but it will have branches and subsidiaries and companies all across the world. It may have in India, it may have in China, it may have in Hong Kong, it may have in Dubai, etc. This means that they must comply with multiple international or regional regulations and compliance requirements. So if they have a branch in European Union nations, GDPR applies to them. Complexities increase since data compliance differs in each continent, each country, and sometimes even each state. All right. Now, if you're staying in United States, you have New Jersey, you have New York, you have Texas, you have California, etc. Each state may sometimes have individual laws which may be applicable to you. Companies face different regulatory obligations in various geographies. Example, GDPR dealing with data of EU citizens. All right. So there are specific laws which are applicable in terms of the data protection. There are specific countries which have their specific regulations, and those need to be complied at every single jurisdiction. You can't say you are compliant with USA because your parent company is USA. If you violate a law in terms of privacy law which is applicable in India or European Union, then you are liable to pay a fine and face consequences legally in those jurisdictions. Cloud service providers often provide different levels of control in the cloud than in the data center. That leaves financial service firms to build the right control to address how they store and use data and who can access it wherever it is. All right. Now, when it comes to the banking and financial industry or insurance company, what the companies do is that they may have complete data of everything, but what they will do is that they will keep controls on it so that jurisdictions which require disclosure of certain information and in compliance with those, they will only provide access to those informations. Jurisdictions which require compliances with reference to certain information which should not be provided in public, they would not give that particular data out there in that jurisdiction. So they have complete data, and then they put control mechanism jurisdiction wise so that each jurisdiction has access to data in compliance with the laws. All right. Very important in banking and financial sector because leakage of data can create havoc as well as legal consequences for these companies. Regulators express concern over the amount of sensitive information cloud service providers maintain, often without being subject to stringent regulation that governs banks. Financial service firms and cloud service providers need a common security framework and complex security infrastructure. Another challenge of banking and financial industry is dealing with structured and unstructured data. All right. So these are the issues which have come up, and this is how we think that it should be addressed, where there should be a common security framework which should be developed so that you can then build in checks and balances and control mechanisms how data can be accessed in terms of the business policy which you have in place and the jurisdiction where the data is being shared. Okay. Speaking about privacy, then we went to the cloud setup, and then we spoke about the much important regulatory and compliance challenges in terms of cloud when it comes to banking and financial industry. We now go to the aspect of the confidential data theft attacks which happen and the legal ramification to that. All right. So one is the privacy of the data, and one is the data theft which happens where you don't disclose data, but somebody hacks into your system. In one of the biggest exposures of data breaches, over 700 million email addresses and nearly 22 million passwords were reportedly compromised last month, which is about October 2020 when this presentation came up. Data theft was among the top 5 global risks along natural disaster, cybercrime, and climate change in the World Economic Forum's Global Risk Report of 2019. Legal ramification would involve government fines, penalties, and in extreme circumstances, even jail time are some of the consequences for not protecting personally identifiable information adequately. All right. So we saw now the consequences of non-compliance is so high when it comes to data privacy and the technology, which is non-negotiable field which we are dealing with, that everything is under technology, but we need to still have data security we need to have still protections, we need to have still compliance of the GDPR and other privacy laws, and we need to protect the data against any data theft. All right. A ramification many do not consider is the cost of data breach in terms of reputation and litigation. All right. So when Marriott had an issue of credit card details which were leaked, the cause which was found was a very minor one, a minor error which could have escaped anyone, but then it caused them a lot of reputation and litigation because after all that was a gap in the system. Many of the associated lawsuits can end up as class action lawsuits, potentially multiplying the total cost of the breach exponentially. Settlements can be harsh depending on the judge or jury. Another cost of breach, including having to pay plaintiffs' legal fees, which can be extremely high. Uh, Organizations must protect sensitive data to reduce the possibility of data breach. However, organizations need to be also prepared for the eventuality of one which can happen. All right. So it's that you put every checks and balances in place, but you need to still be ready to face one eventuality because technology is an overarching field which keeps on developing. Hackers try to find out new mechanisms how to disrupt your business. Going through all the things what we have spoken about, we've spoken about data privacy, we've spoken about cloud service agreements, we spoke about the regulatory and compliance challenges which come when the data is on the cloud, when you're dealing especially with banking and financial sector, and we spoke about the confidential data which leaked because of a data theft which has happened and the consequences we spoke about for non-complying with the privacy law. One of the biggest example is the GDPR law, which is applicable to the data which you receive from European Union citizens, and this data is protected under the GDPR law. GDPR is well known to the world. It's about general data protection regulatory regulation. The EU's GDPR defines a personal data breach as a breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure, or access to personal data. So it's a very wide definition. Any breach which happens to it gets covered under the GDPR. The GDPR sets a maximum fine of about 20 million euros, which is about 18 million pounds, or 4% of annual global turnover, whichever is greater for infringement. That's the biggest penalty consequences you have. Sweden Data Protection Authority has fined internet giant like Google 75 million Swedish kroner, which is about $7.6 million. Which is about $7.6 million for its failure to comply with the General Data Protection Regulation GDPR. So Google already has faced the music. A lot of companies of such nature in technology field have this controversy which is in and around them in respect of GDPR. The GDPR authority also has powers to impose a temporary or definitive limitation, including a ban on data processing by an organization, which means tomorrow it can pass an order saying that in future, Google can't process any data because that company has been found guilty under the GDPR law. Now, once we cross the threshold of GDPR, one of the important aspect which comes is about the integrity of the customer data or any third party data which the organization is handling presently. All right. Now, when you speak about customer data or a third party data, means that if you are a Netflix and if you are a customer of Netflix, Netflix has your data, the customer data, or Netflix also has some third party data. For example, they have data of the person who's given them the movies to be shown, and some other analytics and data of any third party which they have received. Now, how do you secure integrity of that data as Netflix or as an organization which is possessing customer data? It can be a bank also, it can be anything. Data integrity in this environment refers to the state of your data and data management. Data integrity is defined as data accuracy, consistency, and reliability of data stored in databases, data warehouses, data marts, or any of your internal data storage locations. Most important checks and balance to ensure that there is a data integrity. Now, we are talking about two things here. Number one is the integrity of the data which is stored in your system so that there is no leakage out of it. The second important aspect we are talking about is that whatever data you receive, that data integrity, the authenticity of the data should not be changed. For example, if I am a customer of the bank and I've given certain data about my name, address, date of birth, etc., no one should be able to go to the system and change that data without my knowledge and therefore tamper with that particular data. So, number two is the tampering of the data. So, integrity of the data means any unauthorized access by a third party or any tampering of that data. Now, if you talk on that aspect within your organization, these are the most important checks and balances which you have to ensure for your data integrity and security. Number one, all computer systems should be data compliant, data privacy compliant, technology compliant, technology prevention compliance, technology tampering compliance. All right, which means that you maintain log data, etc., against the leakage or access by a person. Number two, there should be an internal audit of that. Number three, there should be a software development life cycle. All right, there can't be an outdated software which is lying in your system which can be easily accessed by breaking into it. Number three, validate your computer systems. Your license should be intact, because if your license has expired in some of the data protection areas, or if a particular license on confidentiality has expired, there are consequences attached to it. Number five, there should be an audit trail. Who has entered the data, who has accessed the data, what data has been accessed, what change has been made, whether the change is authenticate or has been authenticated, etc. Error detection software. The software has no error which automatically disrupts the data. Limited system access. There should be control over the access to the systems. User training should be given on what are the do's and don'ts in your particular area of operation. All right. What is your backup and recovery plan in case something goes wrong? And the 10th is make a data integrity a priority, because that's very important and that's very consequential if you have any data leakage which is happening from your end, whether it's a customer data or any third party data which is there on your systems in an organization. Okay. So these are the aspects we have overall spoken about in terms of guiding your companies towards data privacy, data security, and during the technological environment, especially cloud, which is operated in your company. Next, I will give you two examples of data leakages which happened in India and two examples of data leakages which happened internationally, just to give you a glance that the world is the world consists of people who can hack into your data, and there can be a data leakage, and therefore you need to be taking precautions before anything happens or goes wrong. Especially, I do remember that the Marriott case, there was a small gap in the system which got missed out, but then that system was accessible for many years, and that brought a lot of disreputation to the group. All right. So when you talk about cyber security, it's about privacy, it's about hacking, it's about IP infringement because somebody steals your IP. So those are the kinds of issues which are there, and therefore we need to keep at the back of the mind that how important this subject is when we are discussing today. All right. So when you talk about cybersecurity, the industry suffers billions of dollars due to computer or network hacking, cyber stalking, spamming, software piracy, corporate espionage, money laundering, embezzlement, password sniffers, snooping, and webjacking, etc. When you talk about technology and intellectual property rights, the common form of IPR violation is software piracy, infringement of copyright, trademark, patents, service mark, theft of computer source code. Today, Google has the source code, Facebook has a source code. That's the technology and the IP which brought these companies to the highest levels where they are today. Theft of technical know-how, etc. Tesla today, an electric vehicle, most of their technology they have provided to the public for users because they want to promote electric vehicle. But there are companies like Google Car, etc., which are developing certain source codes or technical know-how for futuristic Google Car, which is very important and private to them. All right. Cyber security cases to India cases. The number one case we had was about Sony India case. India saw its first cyber law conviction in 2013, a very peculiar case. It all began after a complaint was filed by Sony India, which runs a website known as sonysamban.com. All right. Sony Samban means sonyrelations.com, uh, which was targeting non-Indian residents. The website enabled NRIs to send Sony products to their friends and relatives in India after they pay for it online. So Sony India started a website where if you're staying in the United States and if you want to gift any Sony products to your relatives or friend in India, you can use this website. You can pay online, and the things like television, etc., will be delivered to your friends and relatives in India. Okay. In May 2002, according to the cybercrime case study, someone logged into the website under the identity of Barbara Campa and ordered Sony color television set and a cordless headphone. She gave her credit card number for payment and requested the products to be delivered to Arif Azim in Noida, one gentleman in Noida. Uh, the payment was duly cleared by the credit card agency and the transaction was processed. After following the relevant procedures of due diligence and checking, the company delivered the items to a gentleman known as Mr. Arif Azim. At the time of delivery, the company took digital photograph showing the delivery has been accepted by Mr. Arif Azim. The transaction closed at that, but after 1.5 months, the credit card agency informed Sony that this was an unauthorized transaction as the real owner had denied having made the purchase. Investigation revealed that the person who received, Mr. Arif Azim, who received the product from Sony while working at a call center in Noida, gained access to the credit card number of an American national, which he misused on the company's website. All right, so this was the first case. The second case which happened was about a banking case which happened in Pune, which is apart from Bangalore. Pune is also one of the software capital in India. In August 2018, the Pune branch of Cosmos Bank was drained of rupees 94 crores, which is a very big amount, in an extremely bold cyber attack. By hacking into the main server, the cyber thieves were able to transfer the money to a bank in Hong Kong. Along with this, the hackers made their way into the ATM server to gain details of various Visa and RuPay debit cards. The switching system, that is the link between the centralized system and the payment gateway, was attacked, meaning neither the bank nor the account holder caught the wind of the money being transferred. According to the cybercrime case study internationally, a total of about 14,000 transactions were carried out, spanning across 28 countries using 450 cards. Nationally, 2,800 transactions using 400 cards were carried out. This was one of the kinds, and in fact, the first malware attack that stopped all communications between the bank and the payment gateway. The transaction of over rupees 94 crores in a cyber attack at the customer's bank overall impacted the state of the cybersecurity that could not alert the bank. Can you imagine? This was a circumstance where even the bank was not alerted, and it came to know later on that these transactions happen, and see the amount of transactions which have happened. We now talk about cybersecurity cases, two international cases. Number one case was very well known. There was a movie, The Interview, which was based on North Korea. Sony Pictures was one of the companies, the production house. In 2014, Sony Pictures were hit with a crippling virus. Cybercrime group called Guardians of Peace were behind the apparent blackmail attempt, which saw about 100 terabyte of sensitive data stolen from the company. Uh, it is largely thought that the attack was related to North Korea's disapproval of the film The Interview, which was based on the ruler of North Korea, which humorously predicted Kim Jong un and contained a plot where main characters attempted to assassinate the head of the state. US government agencies investigated that the claim that North Korea had authorized the cyber attack in an attempt to prevent the film from being released. The second international case, very prominent relating to financial industry, was about JP Morgan, JP and Morgan Chase and Company, which became a target of a giant hacking conglomerate in 2015. Some theories try to relate that to Israeli theory. Late in 2015, three men were charged with stealing data from millions of people around the world as part of a hacking conglomerate that spanned the best part of a decade. The trio themselves allegedly described the incident as one of the largest theft of financial related data in the history. Uh, Thought to have been operating out of Israel, the trio targeted major corporations, including major US bank, JP Morgan Chase and Company, stealing personal data and then selling it on a large network of accomplices. So they did not only steal the data, they also tried to sell the data on a large network of accomplices who were part and parcel of this conspiracy. The group stole information from more than 83 million customers of JP Morgan alone and are thought to have made hundreds of millions of dollars in illegal profits. Along with personal data, the hacking group also stole information related to companies' performance and news, which allowed them to manipulate stock prices and make enormous financial gains. Using more than 200 fake identity documents, they were able to facilitate large scale payment processing for criminals and illegal Bitcoin exchange and the laundering of money through approximately 75 shell companies and account globally. So that's the consequences we are seeing when we give you the guidelines on the data security, data privacy, and technology, where these guidelines become so important that it's not only followed in spirit but also in letter, and you keep on constant vigilance to avoid any consequential things which we are just seeing on the screen in terms of the cases which have affected large conglomerates with consequences. uh, that's again my profile. You can reach out to me at any point of time on LinkedIn. uh, uh, while we close our subject on guiding your organization on uncertain futures and the new ideas about data security, data privacy, and technology, this is what the guidelines I would give it to you to be followed when you're protecting the data privacy, and using the technologies of today's date. While your organization deals on a business level, you provide the protection ring which is required, so that there is a compliance of law, there is a protection against any cyber theft, and when you use the technology, you're using that technology with the ring of the security which is required therein. Thank you very much once again. Any questions, I'll be very happy to take it. Thank you very much.